We can go ahead and get started. Ian, we can go ahead and get started.
Okay.
Sorry for that. Xiaohai texted me that he could not find the link. Can you send the link to Xiaohai again? Yeah.
We'll take care of it.
Yeah.
But we need to go ahead and get started.
Okay.
Ian, can you introduce our first speaker, please?
Okay. Dr. Hao will present first. Is
Okay.
it? Okay.
Fine. Yeah.
Yeah.
So I go to, say some welcome remarks, and then
I will talk. So I will introduce first.
Okay.
And
sure.
this
Yeah.
let me both speaker first, and then I will do a little bit background introduction, and then I will invite you to talk about the topic today. Yeah.
Okay. Sure. Okay. Yeah. Sounds good.
You can begin your presentation. Thank you.
Xiaohai said he is in Zoom but not in the panel list.
Oh, I'm in here.
Oh,
I'm here
okay.
Now. Sorry, yeah,
Okay.
I'm here now. Yeah.
Okay. Oh, so I have you prepared for the introduction of two speakers today.
Yeah. Do you want to introduce?
Yeah,
first?
if you get prepared, please do the introduction.
So yeah. Oh, sorry. So I will
because
introduce...
I prepared the question part, but I haven't
prepared
for the introduction. Yeah.
Okay. So yeah, I will. So the first speaker will be Dr. Hao.
Yeah.
Because I saw his slides. So yeah.
Right.
So I will introduce Dr. Hao, Qiang Hao. So Dr. Hao actually comes from a very strong biology background. So he got his PhD degree in applied biological science, and also he did many years postdoc research in our Texas Medical Center. So he actually published a lot of papers, and I think he is a very good scientist before he started his career in the law industry. So when he while he in the law school, so he put his emphasis on the courses related to the health law and also intellectual property law, and also he is very interesting in the immigration law. So as a law school student, he's served as a student attorney, and also helped to deal with a lot of difficult immigration, U.S. immigration cases. So now Dr. Lo founded his own law company, which is called Hao Lo PC. So his company observed his law company is focused on four different area, including the immigration law, health law, intellectual property law, and also business law. So I think So I think Dr. Hao can start his presentation.
Okay.
Thank you. Yeah.
Thank you for Dr. Fang's introduction, and I'm so glad to be here to GCC to introduce a little bit about U.S. immigration law, especially those related to the national interest waiver and also the extraordinary abilities, EB1A, and I will also introduce a little bit about EB1B. Okay, so this will be my main topics today. So before that, okay, let me. Dr. Fang has already introduced a little bit about myself. So actually, okay, so here is my short bio. So basically, I grew up in Northeast China, in the city of Changchun, and I graduated with bachelor degree and master degree in biochemistry from Jilin University in China. And after that, I went to Belgium, so completed my PhD degree in applied biological science with a focus on plant biotechnology from the the Dutch name is called KU Leuven, and the English name is called Catholic University of Leuven. Okay. After that, I went to Houston, Texas. Okay. And stayed there for in the medical center. Stayed there for 5 years. I completed several postdoc research program, and in the meantime, I got my green card and started my part-time law school study at the University of Houston Law Center. So I graduated in 2011 and obtained my license in 2012. Then I started my law school, my law firm. So it has been more than 10 years. And at the beginning, it was only me. And now we have a team of about 20 members. Okay, so I will introduce that later. Okay. Now let's first go to the core topic of today. Okay, so how to get a green card as a researcher. So normally, okay, this is the overall process to get the green card for employment-based categories. So first, labor certification. That means most of the time you need to find the employer who is willing to submit a labor certification. And once it's approved, you get I-140. And then depending on your country of origin and your country, you wait for some time and then file the I-45 and get the green card. After the green card, you can still choose to become the US citizen, or you just can keep the green card status forever. Okay. Then why there's something special for researchers? That's because, okay, for the researchers, so basically you have the, normally you have the following options: EB1A, EB1B, and also national interest waiver. So why people would choose these categories? The main reason is because, okay, you can pretty much skip the labor certification step, which means you don't need the employer. Okay, okay, EB1B you do need the employer sponsorship, but for EB1A and the national interest waiver, you even don't need the employer. And for all these three categories, you can just skip the labor certification step and go to I-140 directly. So that means actually, okay, you know that green card process could be very time consuming and takes a lot of efforts. So whatever efforts you can save, that actually will make your green card process much easier. Okay. And so let's first go to the first category. It's called the EB1A. Okay, so normally this is something according to the US immigration law, it could be a very high standard. Normally it's reserved to the top performers in your field. So normally, so the immigration law set 10 criteria, like okay, from award, membership, publication, and so on. Okay, so basically you just need to prove that you qualified for at least the three of them, or sometimes, okay, if you're really at the top of the field, you even don't need to prove any of the three of them. But normally, okay, so for example, if you're a researcher and you have won the Nobel Prize, okay, then it's a no-brainer. Okay, you don't need to show that you have publications, you have awards, and you have media reports and so on. But the problem is, if you are at the level of the Nobel Prize, then I think that you can qualify probably at least 6, 7 of these criteria, and that's normally not something that's reserved for normal, ordinary researchers, because I believe that if you have already won the Nobel Prize, then probably green card is something probably not that you want to consider. Okay, I mean, so we do in our practice, okay, we never had any clients who have won the Nobel Prize. Okay, but we do have some clients who have won the Olympic medal. Okay, the gold medal. That's another award. Okay, but okay, that's normally also very difficult to get. So for most of the case, we still need to prove that you qualify for at least the 3 of them. And normally for the researchers, we need to prove that okay, first you have some publications, so this is very easy to prove. And the second, that's a little bit difficult. You need to show that you have made some original contributions to the field, and it's not only original but also must be significant. So normally, I would say that most of the case, if the USCIS officer thinks that you have some issues with the case, most of the issue would be this criterion called the original contribution. Okay, and then you still need to qualify for the third one. So the third one, normally we would recommend the clients try to find some peer review experience, and many times that's relatively easier to qualify. And just this year, USCIS has issued a new EB1A guidance. So according to the new guidance, you need to so you can show some comparable evidence probably in like awards in media reports, okay, and also sometimes maybe you can show the commercial success and the leadership leading role in the organization, something like that. But still, as far as for the researchers, I believe that these three, the publication, original contribution, and the peer review would be the list that you should qualify. And maybe, yeah, if you want, you can try to find some more evidence in the leading role in organization. Okay, but that's something I think depends on the case by case basis. Okay, and so every day I have received a lot of inquiries, and many times people would ask me, what's my chance of approval, and what's ordinary standard for EB1A. So okay, normally I would just say, okay, there's no certain requirement. But if you really want me to give you some ideas, some rough ideas, I would say that you should have at least some publications, and these papers were cited for a reasonable number of times, like 200 to 250 citations, and also probably some peer review experience, like from 8 to 10 times. Normally, the last one, I think that the less important. But again, I would just say here, and I will also tell every potential clients, the EB1A is not a number game. If it is, then probably you even don't need a lawyer. You can just count the numbers and just show to the officer, and you will get approval. But in real life, we have seen many cases got approved with less impressive numbers. For example, only 100, 150 citations. And in the meantime, there are a lot of cases, even with 1,000 citations, got denied. So there are many factors which determines whether your EB1A can be approved, even includes your luck. Okay, but anyway, so I think that with these numbers, probably at least you can try, and there's a reasonable chance of approval. Okay, now let's come to EB1B. Okay, EB1B actually, I would say it's relatively easier, and first of all, it only has 6 criteria, and you only need to qualify for 2 of them. So normally, we would choose publication and original contribution. Normally for the citation numbers, I think that even you only have maybe 50, 100 citations, you can try. But the most difficult part for EB1B is not your own credentials. Many times is okay, whether you could secure a permanent job offer from your employer. So first you need to, of course, you get the sponsorship from your employer, and here employer not only mean your professor, your supervisor. Okay, it requires like your school or your institution. And I know that many of the universities and research institutions, they have their own policy. So because we have clients from everywhere in the country, and actually we have a lot of examples. So for some research institutions, they are very generous on the EB1B sponsorship. Even if you are just like a postdoc, okay, the postdoc title doesn't qualify, but they can just give you a slightly different title, like a research scientist, research associate, sometimes even like a research investigator also qualify. But for some other universities, they are very strict on this. And many times only the tenure track assistant professor could qualify. So if you think that you don't qualify for EB1A, but you may have a chance for EB1B, then try to first talk to your supervisor to see whether the supervisor is willing to help. And after that, the supervisor may talk to the school officials to see whether they have such policy to sponsor like non-tenure track faculty. Okay, so sometimes maybe you'll have surprise. Okay, and okay, so we just talk about EB1A and EB1B. So if you don't qualify for either of them, then you still have the next one. It's called national interest waiver. So the national interest waiver is good for actually for those non-Chinese and non-Indians. Okay, because for Chinese, okay, here Chinese I mean those who were born in mainland China, and the Indians. So for IW, normally there's a very long waiting period. So many times, whenever possible, clients want to try EB1, and we will also try to help clients to get the EB1 approval. But if we are non-Chinese, non-Indian, then probably the national interest waiver is the way to go, because it's relatively easier, and the waiting period is not that long. Before 2023, there was even no waiting period, but now because more and more people are interested in this program, so now there is about 1.5 years waiting period, which is still not so bad for non-Chinese and non-Indians. So okay, for the national for the IW case, first you need to prove that you have an advanced degree. So advanced degree means a master's degree or above. Okay, if you don't have, then you need to prove you have the exceptional ability. But normally, I would recommend people, okay, wait at least until you have a master's degree to apply, okay, to avoid additional issues. But some people thought that, okay, as far as I have an advanced degree, I could qualify, which is not true, because you still need to prove that you could qualify for this 3-prong test. So this is something I will discuss in the next slides. In the meantime, I would say that okay, USCIS actually has issued new guidance, I think 2 or 3 years ago. Okay, so there they have some language which show the that the IW would be in favor of those who have STEM degree, and those who got the advisory opinion from federal agency, such as NIH, the National Institutes of Health, or FDA. Okay, so, and also for some non-researcher case, for example, you have you have some entrepreneur experience, they would also consider that. Okay, but I would say that these are still like something that's in addition to the basic 3-prong test. And okay, the 3-prong test is okay. So you can see actually this like very specific legal language, and I would say that something that you feel that maybe you can qualify, but sometimes everything could be wrong. Okay, because I think that's because many people realize the benefits of the IW. So I think that at the beginning of my practice, most of the IW case submitted by the researchers, but most recently we have seen a lot of case submitted by those who in non-traditional field. For example, there are some pilots. Okay, they submit IW, and also some entrepreneurs from other countries. They also try the IW. So then the USCIS, in order to deal with this situation, they have to hire a lot of new officers, and those new officers sometimes they have some very bizarre standards. So we have seen a lot of RFEs. Okay, here RFE means request for further evidence. So at the beginning, if we see the RFE, normally the officer would only challenge the 2nd prong, whether you're well positioned to advise your proposed juror. But now we are seeing RFEs for all 3 of them. And sometimes the officer may even question the advanced degree issue, and also your whether you have a US job offer, something like that. So I would say that IW is a very tricky petition. Sometimes you can think that it's easy, and I would say that as far as your researcher with moderate citation numbers, you can try, and many times you can get approval. But just be prepared that sometimes if you meet some very new officer, or some officer they have preset mind to be picky, then everything could go wrong. Okay. Okay. Now the next question is, okay, the timing of the application. So assuming that okay, you are a researcher and you come to the US either as a PhD student or you come here as a postdoc. So I think that many times other than focus on your research, probably you would need to think about how to get the green card. And so right now, okay, we have seen the trends is like there are more and more applicants, and I would say that these applicants, not only those who are already in the US, we have seen a lot of people, they are currently outside of US, or they are non-researchers. They still want to apply for IW and the EB1A, and many times they can get approval. Okay, so more applicants, and in the meantime, because there are limited number of the immigration visas, so that means longer waiting time. So right now, for EB1A for let's say first for EBIA for Chinese, that's about at least 2 or 3 years, and the AW probably 4 or 5 years, and EB1A for Indian, that's like EB1A right now I think it's about 4 years, and IW it takes about 10 years. Yeah, okay. So for our Indian clients, whenever possible, we will try to get them EB1. Okay, otherwise the wait will be forever. Yeah, okay. And also another trend is random results. Okay, especially for EB1A, because I think that's many people they want to try EB1A, and normally there are like maybe at the same time, maybe there are about 20 to 40 officers. So we have some records for those officers, like whether they would approve the case eventually, even if they issue the RFE. So for some officers, we never received any approval from them. That's so-called the killer officers. Okay, so if you're really unfortunate, unfortunately met those officers, then probably you need to think of some alternative solutions. Okay.
Sorry, interrupt you, Dr. Qiang. You have 2 minutes left.
Okay, no problem. Yeah, okay. So, okay, let's see. Yeah, okay. So I guess we can just stop here. Okay. So how to improve your background? Basically, first of course, just publish papers, and then also try to get some patents, and also get higher title, ask for peer review opportunities, get awards, and get media attention. So I think that it's you can see actually the time that you spend to prepare for the green card, it's actually also the same that the same thing that you need to build the career in this country, because with the papers you can get a faculty position, or maybe you can get into the big companies. So if people ask me, whether what I should do to get the green card, I always say that try work harder, try to get papers, and you will use this result not only for the green card, but also for your future careers. Okay, so I do have some successful case, but I think that people can probably just consult me later. And so here is about some of our client statistics. So we have clients who are living and working in all 50 states, and they were originally from more than 50 countries. And many of them, I would say that after getting the green card, they set up their own labs, clinical practice, or companies, and they actually continue working, collaborating with us for their future careers. Okay, so then here is our contact information. So if you are interested in the green card application, so just feel free to either send me email, send me WeChat message, or call our office. Okay, I think that's all for today. Yeah. Okay.
Okay. Yes. Thank you so much, Dr. Hao. So I think there are some questions, but we will answer this question at the end.
Okay.
So
no
yeah. Okay.
Okay.
So then I think we will welcome our second speaker, Brandon Delaney. So Brandon is actually participate our immigration seminar last year. So thank you again for joining us this year. So Brandon is a native of Northern Ireland. So he received his Juris Doctorate at the Catholic University of America in Washington, D.C. in 2009. So focusing on the representation of the foreign-born nationals and the U.S. employers with their immigration matters. His work includes emphasis on extraordinary ability and the national interest waiver case, as well as EB-1B, PERM, J-1 waiver, H-1B, and the O and the P visa application. So Brandon works with extensively with scientists, researchers, physicians, and other professionals, as well as organizations and employers in both academia and the industry field. So he assists us with their temporary and the permanent visa application on a company, individual, and also in industry institutional base. So he actually speak a lot, give presentation in many conference about the immigration issues, and so he has a lot of experience, immigration experience with our scientists and the researchers. So I think now Brandon, you can start your presentation.
All right, good stuff. So thanks a lot for the introduction there. I will just go ahead. I can't add to that. So thanks for having me back here this year again, guys. So I'm not going to add too much to that. So I'll just go ahead and get started. So yes, I am a lawyer. No, this is not legal advice. Okay, so just keep in mind that anything that is indicated here today should be noted for informational and educational purposes only. And when you do want to have legal advice, yes, talk to a lawyer, but consult with them formally, respect to any personal information or case. So now that we've got the disclaimer out of the way, I will go ahead and sort of start talking about, what you guys face. There's approximately 72,000 postdocs in the United States, and approximately about 40,000 of them are foreign nationals. I've had the good opportunity to work extensively with the National Postdoctoral Association over the years. I currently serve on their advisory council. And so I think that over the years, there's been a lot of positive changes for the foreign national postdoctoral community in the United States. But regardless of where you're from, where you're geographically located in the US, as you sort of navigate the career path or the immigration path, it sort of intertwines with your career path. If you were here for undergraduate or graduate education, you're probably now further down your career path. So you're actually facing different issues. You're not just maybe that undergrad F1 anymore. You're not just that graduate student with the initial OPT. You're starting to having to make decisions and facing different issues in terms of your both personal and professional life. And front and center of this is going to be your immigration concerns. So as a postdoc and as an earlier mid-career researcher, you've got your F1, your OPT, plus your STEM extension, which is good for 3 years. You've got the J1 Research Scholar Visa, which is good for up to 5. And then the H1B, that is good for up to 6. So conservatively speaking, a researcher coming out of their PhD could potentially utilize up to 14 years of temporary visa. Now, obviously, not everybody's going to do that. And there's different pathways to pursue. So who can you help? Who should you talk to as you're sort of making these decisions? Well, just remember that if you are in academia, you're still under the umbrella of the international office. Okay, so they will be the ones sort of holding, sponsoring your visa, whether that's the F1, the J1, the H1B. So, talk to them. They're a resource. You're going to have issues, questions, concerns that, they may help you deal with. What about your career office? I think it's fair to say that a lot of decisions that you're going to make as you navigate this journey via the US immigration process are going to become intertwined with your career-related decisions. You're going to potentially have to exhibit flexibility. This is not a sort of one-size-fits-all process. It's not a one-size-fits-all answer. We all have different hats here. in terms of how we're going to navigate this. Go talk to your career office, because they'll give you, some ideas, maybe non-traditional transitional careers that you can still utilize to navigate. Your postdoc office, networking organizations should be proactive, just like today, setting up these sessions, visit the sessions. Don't just turn up at the immigration and visa session, turn up at the CV writing session, turn up at the LinkedIn session, turn up at the science writing section, because all of these will give you a well-rounded sort of professional background, which can enhance your immigration and visa application when you get there. Really important to stay informed. But with that being said, I know everybody goes on the forums. You don't have to tell me, okay? I get it. Everybody talks to the friends. But keep in mind that friends and forums is not always the best place to get solid information, okay? It's not just what, my buddy did, or it's not just what my colleague did. There's a lot of good information out there. There can be misinformation out there. So just be careful and cautious about where you're getting your information. But stay informed, okay? There's also a lot of conversations that are going on out there. Oh, this bill's in Congress. There ain't nothing past Congress in God knows how long. So just because bills are being introduced doesn't mean the sky is falling in, okay? So stay informed about what's going on and what has been going on, what's been happening, sort of broadly speaking, in USCIS, in the world of sort of professional business employment and immigration. No question that we are experiencing delays and inconsistent timelines. And look, that's frustrating. I get it. When you have a friend or a colleague who I just said we all talked to in the forums or whatever, and they filed their green card application 6 months ago and they got their approval in 4 months, and you filed yours 9 months ago and you're still waiting. What does that mean? What's wrong with your case? Well, maybe nothing's wrong with your case. It's because USCIS are pretty inconsistent in terms of their timelines for adjudications. We strive for consistency, but it doesn't always happen. Now, last fiscal year, and actually not last fiscal year because we're now in this fiscal year, but the fiscal year before, USCIS actually raced to issue a lot of green cards. And listen, I deal with USCIS on a daily basis, and I do have to give them some credit that at the end of the sort of in or around sort of August and September of 2021, they actually cleared out a lot of backlog of I-485 and green card applications that were pending, which was great if you were in line at that time. It sort of kind of had a knock-on effect in post-that. It's sort of led to more retrogression and backlogs, which I'll discuss in a moment. Previously, in olden times, all of your EB I-485 applications, you would be interviewed. Well, many years ago, they were processed without an interview, and then the Trump administration said, no, we're going to want everybody to get interviewed. Well, now that's been pulled back. So basically, the National Benefits Center are looking at your I-485 adjustment status, and most of them are being finalized by local offices. So, the chances are you would not be called for an interview. But what are some of the other issues that you're facing? Well, if you file your adjustment of status, generally speaking, USCIS used to issue what's called a combo card. You would get a little employment authorization document, which would also indicate that it was valid for advance parole. There is a lack of combo cards being issued. What's the problem there? Well, the problem, therefore, is that you may have your employment authorization issued, but you may not have your advance parole. So you might get stuck here. And that's collateral damage. We want to get on with our lives as we're navigating the visa process in this country. And there's definitely hurdles and obstacles in front of us. So I think that it's important to sort of understand that, that while we would wish for sort of seamless processing on different aspects of the visa journey, there's going to be some hurdles. So be ready to exhibit some flexibility as you make the decisions by which you navigate this process. As Dr. Howe mentioned earlier, there has been more significant visa retrogression this year for all other countries. EB2 NIWs for the first time in years has now experiencing delays. Forget about it for, as Dr. Howe mentioned earlier, forget about it for Indian EB2s. Those, even those that says 2012, we really don't know how many are in the backlog there. China, less so. So we're going to have more uncertainty about timelines moving forward from here. And I think, therefore, planning planning your forward movement, planning your future, when to file, what other steps to take is going to be pretty important. But with that being said, over the last year and a half, nearly 2 years, there's been a lot of chatter for a number of years about how there should be more sort of deference or information or weight for STEM related applicants. And for a long period of time, that's all it sort of was. It was just chatter. And then the Biden administration said, well, you know what, we're actually going to do something about that. And so in January of 2022, they provided written guidance discussing the evaluation of evidence for national interest waiver applications and O1 visa applications. So what does this mean, or what did it sort of relate to? Well, even though previously your PhD was one of the requirements to be able to file, it's an advanced degree requirement, now a PhD in STEM is seen as persuasive in a national interest waiver application. Additional weight are granted to expert letters from governmental entities and agencies for these types of applications. Does that mean they're easier? No, not necessarily. The standard is the standard. But what it does is it allows USCIS officers to have a little bit of more, latitude, I suppose, in terms of the evaluation and analysis of evidence. So that's definitely has been a step forward for STEM applicants in the EB2 NIW and the O1 processes. So what about EB1s? Well, that was left untouched for a period of time until just recently. I think Dr. Howe referenced this in his discussion, that we just got in July 2023, some guidance that would give additional sort of the ability to provide evaluation of evidence for officers and things like that. So therefore, the standards remain unchanged. The standards are regulated, but the review and the evaluation of the evidence that may be persuasive to officers, for example, in the EB1 universe, has now been broadened and gives us the opportunity to positively argue cases in perhaps a stronger manner. So what about these different visas that you guys have to sort of navigate? And I'm just going to sort of run through these fairly quickly so we can have some Q&A at the end. I referenced earlier F1, J1, H1B. Well, your F1, your OPT in the STEM extension, your optional practical training, post-completion OPT is good for 12 months. However, I assume everybody in this room today is in STEM, so you're probably going to be eligible for the STEM extension, which is good for an additional 24 months. A couple of things to note on that, and to be clear, STEM, OPT in the STEM extension is very heavily regulated. So you have to be careful that you don't sort of engage in any type of activity that could be considered to be unauthorized. Okay, but a couple of quick pointers. It's good for an additional 24 months. You must have a qualifying STEM degree. Interestingly enough, your employer under the STEM extension must be e-verified, and there must be a bona fide employer and employee relationship. So the idea of volunteering or self-employment, which in certain circumstances may be applicable or allowable or authorized under post-completion OPT, is not permitted under the STEM extension. If you utilize your OPT and your STEM extension to leave academia, the one thing I would suggest is to be careful about next steps, because it can potentially limit your next visa options. So last year, for example, the H1B cap, if you move into industry, you're going to have to enter the H1B lottery, and you could potentially run out of chances. I mean, last year, I think there was in excess of 400,000, maybe close to 500,000, something ridiculous, applicants for 85,000 slots. So you're looking at a 1 in 4 to a 1 in 5 opportunity. So, just be careful, because if you sort of use the OPT and the STEM extension to jump to industry, you could be running into some sort of, again, these hurdles that you may have to overcome. J1, hey, listen, anytime you don't have to deal with USCIS, that's not a bad thing. If you're in an academic world, it's fairly easy to administer and is transferable within academia, less so industry, although it is becoming a little more common for certain companies, organizations, industry-based entities to actually use the J1 Research Scholar visa. If you're married, your J2 spouse can apply for employment authorization, and there's 1 or 2 tax treaties that can confer a little benefit on you. 212E. If you are here using a J1 visa as a J1 research scholar, you may be subject to the 2-year home residence requirement. It's something you need to look at, understand, and if you are subject, be ready to deal with it. Generally speaking, if you are a researcher, academic researcher, you will be subject based upon either a country's skills list and or who gave you money. Okay, so if you're subject to 212E, you need to get a waiver before you can change status, before you can get a H1B visa, or before you can get a green card. If there's a discrepancy, so if, for example, your visa stamp says not subject, your DS 2019 says you're subject, well, which is it? You can get an advisory opinion from the Waiver Review Division of the State Department to clarify what's actually the status of your J1. So that's obviously a very commonly utilized visa for postdocs and early to mid-career researchers. Then we have the H1B. I mean, I think the big one is, are you CAP exempt or are you CAP subject? Well, if you're in academia or working for a nonprofit research organization or some other very limited exceptions, you're exempt from the CAP. Therefore, such an employer can file a H1B for you at any time. If you make the jump to industry, you are CAP subject. And as I mentioned earlier, the numbers are very significant in terms of being able to qualify for the H1B lottery. And it's not becoming any easier, although USCIS are making some moves towards limiting potentially how applicants have been sort of forum shopping a little bit, and to perhaps put that back on the applicant that an individual may only be able to enter the lottery once. H1B is quite different from the F and the J in that it is considered to be a dual intent visa. Therefore, you can maintain your H1B up until the day you get your green card. No issues over traveling, no issues over visa stamps, no issues over things like that. But know the policy where you are, because regardless of institution, university, wherever, titles and positions matter. There may be administrative procedures in play at University A, which is different from University B. So again, talk to the people who matter. Under the previous administration, we were dealing with higher levels of scrutiny and standards of adjudication, certainly with regards to wages and types of position. That's been pulled back a little bit under the Biden administration, but I think it can still be an issue. Although I think it's fair to say that it's usually pretty surprising if we get pushback on a scientific research position. What about the O1? Great option for industry. If you want to go to science or business, the O1A, very similar to the EB1A visa category that Dr. Howe referred to earlier. Important to note that a waiver, if you're subject to the 2-year home residence requirement and you cannot get a H1B, you can get an O1. A waiver is not required to get the O1. The employer would have to sponsor you. Case would be approved, you'd leave and then return. The 212E requirement under that scenario would still exist. It's a good option for industry if and when there are no H1Bs available. But it is a restrictive standard, so I think you have to go into that with your eyes open. As I mentioned, there has been some recent deference to STEM, but again, unfortunately, I don't think we see complete consistency from officers when they are adjudicating these cases. So the application of the guidance is also important when we're looking at how an O1 may be approved. This was touched on earlier, so I'm not going to get into it too much, but employer-sponsored versus self-sponsored. Employer-sponsored green cards is your traditional method. You do perm, you do labor certification, employers driving the bus. But what about self-petitioned options, which Dr. Howe mentioned earlier? Well, here you are the one driving the process, okay? So I think it's fair to say and important to understand that it does give you additional options, and therefore it can open doors for you. But it is a restrictive standard. But be prepared and understand the process. Now, I think it's fair to say years ago, the idea of EB1A or the National Interest Waiver was very research-centric. And so how could you apply yourself in a field and in a different field? Well, now the idea of transitional and non-traditional fields are more in play. And I think the idea of the application of your scientific knowledge in a position that may not be at the bench is still generally okay, as long as there's a research involvement to that. But at the end of the day, if you have the opportunity and ability to process a self-petitioned application, you're going to have more options regarding ongoing employment than if you're under an employer-sponsored application. That's employer-sponsored green cards right there. PERM, traditional method, special handling in a university setting, and then the outstanding researcher, which was mentioned earlier. But what about self-petition green cards? I mean, obviously, Dr. Howe talked about this. Is this something you can consider? I mean, is this in play for you? And I think that's some of the questions that you need to ask yourself. You don't have to run before you can walk. You know, I know everybody wants a green card last week. I get that. But sometimes you have to sort of take your time, because the best time to file is what's best for you. It's not, oh, my friend filed with this. What's best for you? Pathways, decision-making, personal lives. It's all a little different between us. That's the extraordinary ability. I'm not going to go through the categories, they were mentioned earlier, but suffice to say, you need to meet a minimum of 3 out of the 10 listed. I will say that some of them are objective versus some of them that are more subjective. And then once you meet 3 categories, you got to show that you're one of the few at the top of your field. You got to show sustained national or international acclaim. That's the standard. I like the phrase because I talk about that as well. If there's any Nobel Prizes in the audience, come on down. The price is right. Green card's waiting for you. But usually in these sessions, we don't have those. The other is the national interest waiver. I think, again, it's fair to say that it generally would be a more appropriate standard for early to mid-career researchers. You don't have to have this very high standing of one of the few at the top of your field. And it tends to be looked at in a little bit of, I think, a more cumulative manner. Dr. Howe gave us the test earlier, but there it is again. Substantial merit, national importance, well positioned to advance the proposed endeavour, and beneficial for the US to waive the requirements of labour certification. What does retrogression mean? And again, this was sort of touched on earlier, but there's 140,000 employment-based green cards that are given out each year. And those are divvied up between the different EB categories, the different employment-based categories. So we have EB1 through to EB5. No one country or countries can take more than 7% of the quota. So therefore, because of the significant number of Indian and to a lesser extent Chinese nationals who are engaged in research and filing these types of applications in the United States, people from those countries have essentially gobbled up more permanent visas than there is availability for their countries. And so therefore the State Department, using the data that they get from both their own consulates and USCIS, say, well, hold on a second, you can file your I-140, you can file that at any time, but we do not have a permanent visa available to process on your behalf. So we're going to retrogress you. And so for the current bulletin, which is December, and this thing gets published in the middle of each month, more or less, for next month, so you can check it out. For EB1, all countries are current. So if you're not from China, not from India, you can go ahead and file your I-140 and your adjustment of status under EB1 concurrently or at any time thereafter. As was alluded to earlier, India is in July of 2019, China is in August of 2022. We've seen very limited forward movement the first 3 months of this fiscal year, very limited, if any, forward movement actually. So I will be certainly personally and professionally interested to see when the January visa bulletin is published, because that will now be moving into the second quarter of this fiscal year, and we may see them start moving forward. I think that if we don't see sort of forward movement in January and February, we could be in for the long haul on this. So we'll see how that'll play out. EB2, different animal. Everybody is now facing retrogression. All countries January 1st, 2023. China January 1st, 2020. It's not horrible. And then India May 15th of 2012. But that doesn't even mean 11 years. We just have no idea how many Indian nationals are in that backlog. However, even though some of those numbers and dates especially for Indian and Chinese nationals, can be a bit depressing. And you're like, is this going to work out for me? What am I going to do? Is there any point in filing an EB2? I would say, yes, there is. And I would say strategize. And I say, you're going to say, well, why? What's the point? It's going to take too long. So, two reasons. If you are from India or China, to a lesser extent now all countries, first of all, you can hold your place in line by filing an EB2. And so therefore, your EB2 filing, which is a less restrictive standard, can hold your place in line, and then you can subsequently file an EB1 and attach it to the earlier priority date. Second, an approved EB2, let's say you're not at the point in your career profile that you're able to get approved for an EB1 yet, but you get the EB2 and the research doesn't get you to where you need to be. That EB2 allows you to extend your H1B beyond the 6-year limit. And I think that's an important note, is that as you continue to navigate, continue to grow, continue to enhance your portfolio, your overall body of work to a point whereby you are able to qualify for an EB1, because as Dr. Howe alluded to earlier, it's a restrictive standard. The filing and approval of an EB2 gives you that safety blanket of being able to extend your H1B beyond the 6-year limit. And also importantly, if you're on a H1B, by filing and obtaining an approval of your EB2 NIW, your H4 spouse can obtain his or her own independent work authorization. So these are all sort of secondary benefits, I suppose, that we come up against, even though the timelines themselves are sort of, again, a little depressing, and certainly more so for some countries than others. So yeah, that's what I got for you. I've tried to sort of, I suppose, walk you through some of the issues that are in play for this professional field, or this field of professionals. But I do encourage everybody to to network, to go to the different sessions that are available to you through organizations such as this. Join your postdoc association at your university, because the NPA, the postdoc associations, the postdoc offices, they're doing good things. I appreciate that there's a lot of hurdles and obstacles that are out there as well. But if you involve yourself in some of the forums and in some of the processes, you can sort of help each other. So yeah, I'm going to stop sharing my screen now. My contact details are there. You guys will have them. And, hopefully we can do some Q&A.
Yeah, thank you so much for the wonderful presentations. So I think we now will have the panel discussion, and after that, we will answer the questions from our chat box. So, Summer, do you want to start?
Panel discussion. Any stuff you want to discuss for now? If no, we can move to question and Q&A. I think people
just
want to ask
wondering
question
if
more.
Just wondering if any of our CTTP fellows has any questions.
Sure. Any CTTP fellow want to ask question or raise up discussion? Yeah. First.
I have a question. I'm Michelle. I'm one of the postdocs in Michael Taylor's lab. I'm actually Canadian. I'm also a pediatric neurosurgeon, board certified, and I started my postdoc with him. I'm just trying to figure out the visa kind of situation as well. And they brought me down on a TN visa, which makes it temporary. But I've been told that getting the H1B first and then going for the green card after would probably be the best, so that you don't get stuck in the US. Like, you can't leave for conferences, you can't, go to see family if they get sick. And so is that what you would recommend?
I mean, I can jump in if you want. So, I mean, there's a couple of I think there's a couple of different factors to take into consideration. I think where you're going with this conversation is the idea that once you file a green card application, you have evidence what's called immigrant intent. And so therefore the ability to be admitted on a TN after filing a green card application could well be in question. I mean, I think it's fair to say that a CBP officer could say, you filed a green card application, you have an immigrant petition pending or approved. So therefore I would be reticent to admit you under the TN. The flip side of that is that at the end of the day, the employer for temporary visas is the one driving the bus. And it's their prerogative in most instances as to which temporary visa status to offer. With that being said, that's why I tend to urge people to have sort of, if you can maintain a good, clear relationship and conversation with your PI, your sponsor, and say, look, these are the factors that are impacting me personally and professionally. What else could be on the table? Then maybe the H-1B comes into play. But at the end of the day, for purposes of either travel, attending conferences, and at the same time pursuing a green card, a H-1B would be a preferable option to file from.
And after the prevailing wage determination, is that part of the process, or is that you have to apply for it after that?
For what, the H-1B?
Yeah. Because I feel like that's where the status of mine is with the immigration, with the ISO. They said that they're waiting for the prevailing wage determination.
Yeah, I mean, it sounds like they have initiated administrative processing of the H-1B. I personally wouldn't want to comment upon how a certain office or institution or organization prepares and files H-1Bs. Okay,
so there's different ways, I guess.
Well, it's not that there's different ways, just sort of different timelines and things like that. The prevailing, at the end of the day, the H-1B requires a prevailing wage to be part of the application. You have to be paid a certain wage. So that's where they are. It's the process is the process. I just wouldn't want to put my foot in where I'm not party to a case.
Okay. Thanks.
Any other CTTP member want to ask question? Yeah.
Yeah. So if no, actually, I have a question for two speakers. So if we have any our postdoc, if we have any visa or issues, or maybe you want to apply a green card, so we may need to work with immigration lawyers like you. So I just wondering what the strategy and what are your suggestion for us?
Okay. I think it's okay. Can you hear me?
Yeah.
Yeah. Okay. I think it's actually it's a very big question, and I would say that first of all, okay, you just consult the immigration attorney. So like Mr. Delaney and us, and I believe that there are many other attorneys, immigration attorneys, would offer free case evaluation and consultation. Okay. So we would understand your situation and give you some initial suggestions. Okay, like whether you should apply for a green card now, and what's your best shot in which country, and then you can decide. So the only thing that I want to say is that okay, if you really make up the mind to stay in the US and want to develop your career, okay, don't wait, okay, because I have been in the field for more than 10 years, and I have seen many cases. So some people, they come to me maybe 2 or 3 years ago, and say that they want to apply for green card. And at that time, there was still enough time for them to do something. But then they just disappeared. And then after 2 or 3 years or even longer, they come back and say, okay, now I'm in my last stage of J1, my last stage of H1B. I really need to get the green card. I want to stay in this country. But now, actually, you're leaving both you and the immigration attorney in a very difficult situation. Yeah, because we don't know how to help. Yeah, so just do it as soon as you make the decision. We have some kinds. I would say that I remember there were even some kinds they because now okay they can get information from internet. So even before they come to the US, they already want to know the green card process, and they will just start the process immediately after they come to the US. In this way, you have, for example, if you're F1, you have 5 years, 6 years. If you're J1, you have 5 years. If you're H1B, you have 6 years. Then you can do like a very good planning. Okay, yeah, that's it. Okay.
I have a question. So, I like your answer about getting initial very early on, but like for a lot of for postdoc, I think most of the time they can do anytime they want. What about graduate student? Like why should they really consider to initiate the process?
Okay, let me start first, and then probably Mr. Delaney has some more thoughts. So actually, I have seen the recent trend is that we begin receiving a lot of inquiries from PhD students, even when they are still in the very early study, like sometimes only the 2nd year or 3rd year. So they normally they already have the master degree and they have published some papers, so they could potentially qualify for IW, and sometimes some of them even may qualify for EB1A. Okay, but so normally I would tell the clients, okay, first see whether whether you probably talk to your international office to see whether after you file the I-140, whether that will affect your F1, your F1 OPT or OPT extension. Normally the answer is no, but to play safe, I always recommend client to talk to the international office. And also many times, okay, if you don't have like valid visa stamp in the passport, then probably you can, we don't recommend you leave the country and apply for F1 visa. So think whether you could take this consequence, like you stay in the in the US and cannot leave the country. If that's not a problem, and if you already make the decision, then you can just start right now. Okay. Otherwise, you just wait. Yeah. Okay.
Thanks.
Well, I'll just add quickly to that. I think if the question was, as a graduate student, or when to apply, or should I apply? And I think when you look at your CV and your body of work that you have, first of all, it's not a one-size-fits-all answer. It's not that, oh, I'm a graduate student. It's everybody's a little different. But with that being said, I think if you're an earlier career researcher with a more limited body of work, I think the question becomes not, is the case approvable, but what is the overall strength of the case, and is it more likely than not that it will get approved? Because at the end of the day, if you have a master's degree and are engaged in research and have published on 1 or 2 occasions and have maybe presented, you potentially have an approvable case. But the overall strength of the case would need to have more sort of, evaluation, analysis. So I think you have to ask yourself that question. Is my case approvable, or will my case get approved? And I think sometimes those answers can be different.
Thanks.
Okay, I think we can go to our Q&A section. What do you think, Sama? Do you want
Yes.
to read the questions?
Maybe read the question one by one. Yeah.
Okay. Okay.
The first question is, how many or how much citation need for the EB1A application now? Yeah.
Okay, just like I said in my slides, we can give you a general number, but it's really case by case, and it's not a number game. So I would recommend that okay, people just send me or Ms. Delaney a CV, okay, with actually there's a useful tool called Google Scholar, okay, where you can see the your publications and the citations. So and probably we can also have some other information, like whether you have patents, you have some software, you have some like awards. For example, sometimes so there was one case we just got approved. Client has only 200 citations, but she has a K99 grant. Okay, so I think that may play some role, but still, okay, the case is was approved. So okay, I would suggest that just consult immigration attorneys individually, and we'll evaluate case by case. Yeah.
Okay, thank you. And second question is,
Let me just put one other, just to piggyback onto that. I think you also have to remember that fields of science are different.
Yeah.
And so certain areas of the sciences lend themselves to a heavier citation total. Yeah. So for example, maybe others, like let's say you're an aerospace engineer out at Goddard, NASA, you may be actually engaged in very high level work with a very extensive amount of, but your dissemination may be more conference or symposium based or abstract based rather than full journals, which tends to detract from the citation numbers. I think the reality is that if you have a lesser number of citations, it's the elephant in the room, and it's a significant hurdle to overcome for EB1A. But I do agree, it's not a pure data-driven numbers game, and you have to you have to look at it slightly more broadly than that. So yes, I'm in total agreement, but go ahead to the next.
I see. Yeah. The second one is, what if your role is, what if you're in administrative role? I think that his question or her question is, he's a researcher, but his job role is in administrative. How he or she still pursue to the green card application?
So I'm going to say it can be challenging. And here's my reason for that, is that at the end of the day, once you pursue a green card in either an EB1A, extraordinary ability, or an EB2 NIW, you're essentially saying to the US government, I am extraordinary in my field, or I'm advanced degree alien performing work in the national interest in my field. And upon approval of my application, I will continue working in the same or allied field of endeavor. Now, the application of your scientific research knowledge can bring you into transitional or non-traditional fields. You don't have to be stuck at the bench. You can go into industry-based entrepreneurial research a lot. But if you pivot away too far away from that, then you're not really in that research arena. So which role is it? Are you petitioning in your role as an administrator? Are you petitioning in your role as a scientist? So it can, when you move too far away from research, and I use the R word broadly, now you have potential challenges. I think that is fair to say.
Another question is, I have PhD biophysics 140 citation Indian. Currently is postdoc J1 visa and 2-year home residency apply. is there any option for me, or there is no option for the green card application? I think, yeah. Any?
Okay, so again, okay, I think we need to evaluate case on very case specific basis. I would say that okay, without seeing much information, with 140 citations, IW probably is okay, yeah. But even EBA could be challenged. But I understand that this he's from India, so probably IW would take forever. So then yeah, so EBA, I think that's yeah, we really need to sit down and see whether he has any other strengths, okay, to qualify for EBA.
Okay, thank you. The next question is, once a green card is acquired, what is the process and how easy it is to get a green card for dependent parents? Yeah, maybe
you gotta become a citizen.
Okay. The next question is, what are the options for DACA student?
DACA, okay.
Yeah.
Okay, so okay, first, okay, I'm not sure, Ms. Delaney. Okay, we don't practice in DACA, so I think that's so it really depends on which field of these DACA students. If he or she is in the science field, probably he can do traditional IW EB1 routes, but still there's the issue like how to go do the second step, meaning adjustment of the status. Okay, so this is something that's actually beyond my knowledge. So I really cannot give a very detailed answer. Yeah.
Okay. How about
I would just add to that. I think that that's a very personal situation. I wouldn't want to veer into legal advice in an open forum. I will say about if you're here on DACA, I assume that this person has probably already been initially approved, as there is a court order, a court injunction precluding people who have not yet received their initial application. And as Dr. Howe pointed out, I mean, listen, anybody, if you've got the credentials to file an EB1A or an EB2 NIW, you can do it. Doesn't matter about your status. It doesn't matter if you're here. I'm from Ireland. If you're sitting in Ireland or if you're sitting in the moon, you can always file. The option is, how do I get across the end? How do I get to adjust status and their unlawful presence issues, things like that? So those are the types of questions that this person should speak to an attorney about.
Right. Next question is, what would be the good pathway to get independent? For example, H-1B to whom arrive here in USA as a J2?
Becoming independent of what? Career-wise or get the green card? Yeah.
Yeah, maybe. Yeah, I'm not sure the question.
Yeah, this question. It's really difficult to answer. I would suggest this person just send the individual inquiry to me or Ms. Delaney. Yeah.
Yeah, and then let's go to next question. Is, can H4 work in USA?
Yeah, just like Ms. Delaney said, in certain circumstance, H4 can get EAD. Okay. And then can work in the US. Okay. Yeah.
Yeah. Another question is, can you please break the timeline I-40, I-140 approval to I-485 approval, the timeline period between those two?
No.
Yeah.
I mean, we have to joke a little bit. The reason I say no is that there are a number of different mitigating factors that can come in here. It can be country of nationality. It can be which visa preference category you were approved in. It can be when you filed. And honestly, if I had any hair, I'd be pulling it out because it is frustrating when we see inconsistencies in terms of timelines of adjudications. We all see I-485 approvals relatively quickly after I-140s, and we see others that just drag on through no fault of anyone's, not even the fault of the attorney. So, you know, listen, it's an inconsistent timeline. I wish we had consistency. So that's a difficult judgment call to make in terms of the approval to the final adjudication.
Yeah.
Okay. So to add something for Ms. Delaney, for I-140 stage, actually you can pay the money to buy time. Okay.
Okay.
The USS would give you the decision within certain time, although not always approval. Okay.
I see.
Sometimes,
I see.
but I-45, it really depends on so many factors, and it's really difficult to say. The best advice I could give that, okay, just get in line as soon as you can. Okay.
Okay.
I think you would have different feeling if you're waiting in line or you're outside of the line.
Right. Yeah. Yeah. This question is also similar to my Lembe. He asked me to ask similar question, but I haven't asked before. But this one always, yeah, inconsistent one by one. Yeah. Next question is, can J2 apply for H1B?
Yeah, for sure. Yeah, but of course, okay. So first you need to get a waiver. Either okay, most of the time it will be your dependent. J1 need to get a waiver, and then you will J2 get a waiver automatically. And sometimes J2 can get waiver by him or herself. Okay, but that's under very limited circumstance. And after getting a waiver, you can find a sponsor. For example, if you are in the school, then you can get the H1B at any time. But if you want to go to industry, then you need to win the H1B lottery. Yeah.
Yeah. Another question is, as you said, postdoc duration is 5 years. I'm wondering how does it count, and it start from joining days as postdoc in USA, or you also count the postdoc done in other country?
Well, I would just want to clarify that I think generally speaking or broadly speaking, the idea of a postdoctoral appointment is on or around a 5-year period. I think it's also fair to say, over my experiences, I've seen people do a second postdoc, or I've seen people do a secondary postdoc. I think one of the things that I mentioned was the J1 Research Scholar Visa, which is utilized by many universities, institutions for postdocs, is good for up to 5 years. So when you're talking about what constitutes a postdoc, does it start from joining dates in other countries here? I think that would be a very case-by-case basis for the individual and how the institution would recognize them. Would they want, if they had a previous postdoc, would they count that time? So I don't think that's a question we could really answer, rather than broadly speaking, a postdoc is about 5 years more or less. But again, that's a pretty fluid time frame.
Right. Okay. So it's a former postdoc. Okay. Probably I can say something. So basically, I think postdoc it's like an experience, and it's not only a title. Okay. So title-wise, after actually, for example, if you couldn't find a formal job and your supervisor still want to keep you, they can always give you another title, like instructor, research associate, research scientist, and then you will not be considered as a postdoc based on title, but actually you're still doing some research which under a supervisor of a boss. Okay, so I mean, yeah, if you really enjoy the research, you can do it forever. But if you really want to get a career, probably because you need to think of something else. Yeah, and I think that in this country, actually you have unlimited opportunities. Yeah, so I have seen a lot of my friends, former colleagues, actually after they get the green card, they become they could do every profession. Yeah, so like they switch to IT. They go to the clinical field if they have some medical background, and they could become a lawyer like me. Okay, many of them actually they do IP or commercial litigation. Okay, so I think that's the benefits of living and working in this country in the US. So basically, you really have a lot of opportunities. So just don't limit yourself and try to get a green card first, because that's the first thing you want to set down here. Yeah.
Right. Yeah. As our question come more and more, so how as our time is almost up, how should we tackle this problem? So high.
Okay.
I don't know. Do you think maybe I think the two speakers can take a look and see if you want to answer some questions, and I think you can decide which one question you want to answer.
Yeah. Just pick up some you are interested.
So I'm a little reticent to, in an open forum, to answer specific questions. That's just my personal and professional opinion. I can flick down through one or two that I see. Right moment to talk to your PI about permanence on a program under a J1. I think that's going to depend upon factors in terms of what your relationship looks like with your PI, and also potentially what the procedures are within your institution. In H1B, steps to enhance a green card, that's going to come down to your professional research credentials. It's not necessarily which visa you hold, it's what your overall body of work looks like. I don't know if Dr. Howe, you want to chime in on any of these, but that's...
No, I think that's, I looked over this question. I think we have already answered most of them. So I don't think I have anything to add. Yeah.
And also, I think if they have any other specific question, you can, like Dr. Howe and Brandon said, you can always contact you, right?
Right.
So, yeah.
Okay. If no any problem, we can, or we should end today.
Okay. Yeah.
Well, I wanna thank Dr. Hall and also the Brandon for the great, really not just seminar, a great introduction to all the topic a lot of people are interested in. So hopefully some of our attendee gonna contact you for further question, and you guys can really respond to their question. We really appreciate that.
It's our pleasure.
Okay. Thanks a lot. Okay.
Yeah, thanks so much for having me. Great session.
Great webinar. Okay.
Thank
Cheers,
you.
everybody. Take care. Bye.
Bye.